I thank you for your presence here, and I am very happy to be here in St. Kitts to share some ideas with you on the rule of law in the Caribbean. Actually, the Honorable Attorney General had given me a list of the very impressive legislative agenda which the present government has set out, all in an effort to comport with the rule of law. And I thought that it was appropriate for me to speak to the rule of law in the Caribbean generally, as distinct from dealing specifically with any particular piece of legislation or any domestic issue in St. Kitts and Nevis. I also welcome occasions like this because they allow one to get a better sense of the pulse of the Caribbean people, while at the same time they allow for an opportunity for me, as a judge of the Caribbean Court of Justice, perhaps to say something to you about the work of the court. I think this kind of dialogue, this periodic exchange of information and views, itself has a role to play in fostering respect for the rule of law, where judges of the apex court can speak to people and take questions from them and have that kind of interchange. The development of the principle of the rule of law is actually credited to the Greek philosopher Aristotle, who developed the concept that it is more proper that the law should govern than any one of the citizens. In other words, even the king, the ruler, the supreme ruler, should be under the law. And in this regard, I like to cite a true story that actually occurred in Aristotle's time that illustrates the principle to some extent. The Greek king, the Macedonian king at the time of Aristotle, was a man called Philip II, the father of Alexander the Great. Now, Philip exercised supreme authority over his people. And one day as he was holding court, because he also dealt with judicial issues, people had a dispute, they came to him. One of his female subjects petitioned him for justice. And she stood before Philip, pleading her case. But you see, Philip had been drinking heavily that day. And to be quite blunt about it, he was drunk. In short order, he dismissed the lady's petition and waved her out of the chamber. And she said, I will appeal this judgment. Well, Philip thought that quite a bit of arrogance. He said, to whom? She said, I will appeal to Philip sober. Now, this is a true story. According to the Roman historian Valerius Maximus, the worthy petition was indeed resubmitted, and it was decided in the woman's favor by a clear-headed Philip. The moral of the story is that ultimately what must prevail is law and justice, and not the arbitrary whim of the judge or the ruler, especially if he is inebriated, whether with power itself or with alcohol. The people of this federation, like the people of the entire Caribbean, must jealously guard and protect the rule of law. In part because, as a people, we have come such a very long way in such a comparatively short space of time. Just imagine, less than 2 centuries ago, that's about 4 or 5 generations ago, our forefathers were looked upon as nothing. We were bought and sold like chattel. Indeed, the law regarded us as chattel. Rex Nettleford rightly refers to the Emancipation Act of 1834 as our collective birth certificate. That is when we became humans. That is when, in the eyes of the law, we ceased being property. And it is from that time that we can count steady and rapid progress in reclaiming our dignity and in having our human rights respected. And that continuous struggle also included a struggle against the yoke of colonialism, such that eventually we won our right to self-determination. So that when you look at it in historical terms, in less than 2 centuries, we have come from nothing to a proud and independent people. And if the Emancipation Proclamation was our birth certificate, then our Independence Constitution can be likened to the document that marks our coming of age. But with independence, with adulthood, with the Independence Constitution, has come not only enhanced rights, but also new responsibilities. The Barbadian writer George Lamming paints a very vivid picture of the background against which we take up these post-colonial responsibilities. And there's a quotation that I think is very apt from him. He says, look, colonialism was not a physical cruelty. Indeed, the colonial experience of my generation was almost wholly without violence. No torture, no concentration camp, no mysterious disappearance of hostile natives, no army encamped with orders to kill. The Caribbean endured a different kind of subjugation. It was the terror of the mind, a daily exercise in self-mutilation. This was the breeding ground for every uncertainty of self. The breeding ground for every uncertainty of self. A major challenge we still face is, as perhaps one of our most famous artists has said, Bob Marley, is to emancipate ourselves from mental slavery, to imbue ourselves with the confidence befitting a responsible adult who must stand on his own feet. Yes, we may at times wish to emulate or draw on the experiences of others if the example is useful and suitable to our own unique circumstances. But we need to be firmly aware that we do possess the ability to harness the intellect, and we are actually best placed to interrogate our own societies and to determine for ourselves the optimum measures that must be taken to improve it. If I had to sum up our principal responsibility in this age, I would say that it is to maintain and enhance the rule of law. To my mind, this is an essential platform for achieving and maximizing social and economic progress. But what exactly do we mean when we speak of the rule of law? What are the elements that comprise this precious principle? In my view, the rule of law means a lot more than its most basic ingredients. And those basic ingredients have usually been listed as, firstly, the making of laws in a public manner, with laws being accessible to the population. Secondly, the laws being made to take effect generally in the future. You don't have a law that you wake up one morning and the law says that what you did last week is illegal. Thirdly, the laws must be publicly administered by courts that are independent and impartial. In other words, at its most basic, the rule of law signifies the sovereignty of law over arbitrariness. You don't have somebody like Philip Drunk who simply gives an order and it is carried out, but that rather laws are made by a parliament of persons who are elected, and the laws are made in a transparent manner. People could go to the House of Assembly and see when the laws are made, and the laws are administered not by the people in Parliament who make them, but by an independent body, a court, that looks at the law and interprets it and applies it. So at its most basic, that is what the rule of law implies. But that is not a sufficient condition for the rule of law, because that occurred in fascist Germany and that occurred in apartheid South Africa. Laws were made. They were made by parliaments. Hitler was elected. So it is not sufficient to have those basic ingredients in order for the rule of law to truly prosper. What is also important is that those basic ingredients should be supplemented by legal accountability. People who operate the law need to be accountable. There must be fairness. The law must operate in a fair manner. There must be respect for minorities, which is critical because we operate in a system where the majority could vote in a particular government into office, or the majority could enjoy certain rights and privileges. But minorities, their position in society must also be respected, whether they be persons who suffer disabilities, whether they be persons who have a different sexual orientation, whether they be persons who pray to a different God from the one that is prayed to by the majority of the people. Whoever they are, the rule of law requires respect for minorities. It requires respect for the observance of human rights and for the separation of powers and for equality before the law. You can't have a situation where one person who is very well off, having law being applied to them differently from someone who is not so well off. Our constitutions seek to do these things. Our constitutions are excellent guarantors of the rule of law because they serve as a fundamental brake on tendencies to arbitrariness. They're really designed to keep governments in check, to constrain the actions of all the organs of the state, whether executive, legislative, or judicial, so that under the Constitution, if it is working properly, the executive is not at liberty to take any decision that it pleases, nor is Parliament entitled to pass any law that it wishes. And even judicial power must be exercised with care. Yes, even the judiciary, which is entrusted with the noble task of interpreting and applying the Constitution, judges must ensure that they exercise judicial power within limits. Because if, like the drunk Philip, they carry out their mandate in a capricious fashion, then public trust and confidence in the justice system will be eroded, constitutional values will be diminished, and the very rule of law will be imperiled. So, for example, when several years ago, in the 70s I think this happened, a judge in Trinidad exceeded his powers by holding a lawyer in contempt of court and sending the lawyer off to prison without due process. A higher court said that the judge had overstepped the mark and the lawyer was entitled to redress from the state for the violation of his constitutional rights. Now, I am very deeply honored to sit as a judge of the Caribbean Court of Justice. The establishment of that court is a very important milestone in the orderly delinking from imperial and colonial control. It's the next logical step in the decolonization process. And until it is taken, we cannot be said to have completely rid ourselves of vestiges of our colonial experience. We in the CCJ have not hesitated to take the measures we consider appropriate whenever we were convinced that a Caribbean government was compromising the rule of law. In a sense, we are privileged to be able to apply the rule of law in the Caribbean both on a regional plane as well as on a domestic plane. At the regional level, as you all know, CARICOM countries have made a pact, an agreement, a treaty among themselves, the revised Treaty of Chaguaramas. And through that treaty, they have agreed to encourage the free movement of goods, services, labor, and capital among CARICOM countries. You can think of the CARICOM Treaty, therefore, as a kind of constitution, a document that each country must adhere to. And you can think of the CCJ as the court that one turns to when any CARICOM country violates that constitution. The court, therefore, resolves disputes that arise between CARICOM states under the treaty, or between individuals who live in a particular state and a state that is not living up to its responsibilities under the treaty. Because each CARICOM state has its own peculiar interests, its own priorities, its own challenges, aspirations, and goals, strained relations among states are just as likely to occur as among persons in society. So if we look a little at a few examples, then we could see what can give rise to such strains and tensions. You take a country like Barbados. For its small size, Barbados has a relatively huge population that is exacerbated by the million-plus tourists who visit annually. The relatively dense population places severe pressures on limited social infrastructure and social amenities. But due to its social stability, Barbados is targeted by many Caribbean people who are seeking a better life. And one result of this is that Barbadian immigration officials can be very zealous in protecting their country's borders. You look at another country, Jamaica, the biggest island. It also has the largest population size in CARICOM. Jamaicans are an enterprising people. Their economy is not surging in the same way it was when they voted to separate themselves from the West Indies Federation in 1961. Some Jamaicans now find such great difficulty finding jobs in Jamaica that they are understandably on the move, fully prepared to explore whatever opportunities might exist in other countries. You look at a country like Trinidad and Tobago. That country is blessed with abundant energy supplies, and that bounty has allowed the country to dwarf the rest of the Caribbean in light manufacturing. So that Trinidad is keen to ensure that its manufactured products penetrate the region in preference to comparable products from extra-regional sources. And of course, the not so well-off states in the region would love to purchase cheap products, maybe from China or from the US or Hong Kong or wherever, and not necessarily those manufactured by a sister CARICOM state. So these are the kinds of realities that make for stresses and tensions. Every community must endure them. Their existence doesn't mean that CARICOM does not or cannot work. What it means is that there must be give and take, and that there must be some regularization of these stresses and tensions. The stresses must be managed in an orderly and lawful way so that no serious injustice prevails, or that where injustice rears its head, the wronged party has recourse that they can easily access. In other words, the rule of law must prevail. And the CARICOM Treaty sets out a framework for ensuring this. And the CCJ is entrusted with that pivotal role of dealing with the disputes that arise, so that when a state or an individual feels unfairly disadvantaged because a sister state is not playing by the rules, complaint can be made to the CCJ, and the CCJ is authorized to give effective relief. So it is that we have had cases of Trinidadian companies that complained in one case that Guyana was wrongfully importing cheap cement from outside the region, when instead it should have been purchasing that cement from Trinidad. In another case, the Trinidad company complained that Suriname was importing flour from the Netherlands, when it should have been buying that flour from Trinidad. And in each case, the court gave judgment for the Trinidad company. In the well-known case of Shanique Myrie, here is a young Jamaican lady attempting to visit Barbados for a short holiday. She was not welcomed at the airport as a CARICOM citizen should be. Overzealous Barbadian border officials placed her in a dirty cell and deported her the next morning. They dealt with her in a most inhumane manner. She complained, and the CCJ denounced the mistreatment and awarded her significant monetary damages, which Barbados paid. So in these examples, you see where the court is playing a dynamic role, touching the lives of people, safeguarding the jobs of workers in the manufacturing sector in Trinidad, maintaining the integrity of the CSME, protecting the rights of ordinary Jamaicans, and by extension all CARICOM citizens, and generally upholding the rule of law on the regional plane. The court plays a similar role at the domestic level as the highest appellate court. It takes action to preserve the rule of law and protect the rights of the people. So, for example, we've had a case from Barbados where the critical evidence linking an accused man to a murder was from a dentist who testified that the accused, when he was arrested very shortly after the murder, had a wound on his arm that resembled a bite mark. And the dentist further testified that after he had gone to the morgue and taken measurements of the deceased woman's dental features, he was sure that that wound was a bite mark, and that that bite mark could only have been made by the deceased woman. The problem was that bite mark evidence belongs to a very highly specialized scientific field called forensic odontology. The dentist was not himself a forensic odontologist, and his bite mark evidence was effectively the only evidence against the accused person, who claimed that he did not commit the murder. Further, forensic odontology is itself a very controversial field. As a forensic tool, it is not as respected as DNA or fingerprint evidence. In the United States, reliance on bite mark evidence has actually resulted in many wrongful convictions. So in those circumstances where the man claimed that he needed to retain a forensic odontologist in order to rebut the state's evidence against him, in the court's estimation, a fair trial of this accused person could not have been held if the accused, and bearing in mind that this accused was facing potentially a death sentence, the court held that a fair trial could not be held if this man was not afforded the funds by the state that was seeking to prosecute him to retain a forensic odontologist of his choice, and that therefore the state could take a pick. It could either drop the charges or it could give him the funds to hire a forensic odontologist who could question and query whether the evidence of the dentist was in fact sound. As it were, ultimately the state chose to drop the charges after they had spent quite a bit of money hiring their own forensic odontologist who told them that the evidence of the dentist couldn't quite stand up. In another case from Belize, the court was called upon to examine legislation that had been enacted by that country's parliament that had introduced very steep mandatory minimum penalties for a particular offense. And the court noted then that given our solemn responsibility to protect human rights and uphold the rule of law, courts would usually regard mandatory or mandatory minimum penalties with a very watchful eye, because this is a situation where the legislature, the parliament, is seeking actually to determine the sentence a person who is found guilty of the particular offense should receive. And sentencing ought really to be a judicial function and not a function that the parliament should assume. So we examined the legislation carefully, and the court took the view that the mandatory character of the sentencing regime should be invalidated. It should be struck down. Caribbean governments and parliaments have their own role to play in promoting the rule of law, and they have been doing so. And earlier this evening, the Honorable Attorney General, I think, indicated the measures, the legislative measures, which his government proposes to introduce in order to advance the rule of law. Certainly, one of the challenges to the rule of law in the Caribbean lies in the dangers associated with the over-centralization of power in the hands of some prime ministers. In fact, in a book, the book that Mr. Ferdinand referred to, a book on Caribbean constitutional law, recently published by Tracy Robinson, Arif Balkan, and myself, we drew attention to this feature. In fact, we labeled the dominant system of governance in the English-speaking Caribbean as being prime ministerial government. That is a system where the prime minister wields immense power as the head of government and typically controls the majority in the houses of parliament. Prime ministerial government is evident where there is this concentration of executive and legislative power in one individual, and invariably it leads to a culture of patronage and dependency. It's aggravated by a winner-take-all electoral system. In many countries, we don't have proportional representation. We have single-member constituency, first-past-the-post systems. And so it is possible for a government to win a vast majority of the seats with just a little over 50% of the total votes. So this is one of the problems that we have in the region that reflects itself as a challenge to the rule of law. Another challenge is that political parties that ultimately become, their leadership become the executive, become the government, there is no legislative framework for ensuring that these parties operate in a democratic manner. And that is also a challenge to the rule of law. Because if these parties are run undemocratically, then the results of that lack of democracy naturally becomes a matter of public concern as and when the party gets into office. So all of these measures are matters which we need to address if the rule of law is to be enhanced. Some of these issues were discussed by us in the CCJ in a case where we actually had occasion to decline to enforce an arbitral award that was premised on an unpublished confidential agreement made by a prime minister to exempt a local investor from the tax laws of that country. Here you had a situation where the prime minister of this particular country entered into a secret agreement with an investor where it was agreed that the investor would enjoy a tax regime that was completely at variance with what the law required of investors of that sort. And there was a dispute, and the investor took this agreement before an arbitral body in London. And the London arbitrators said, well, the government must honor the agreement. And the investor brought that agreement to the court to have it enforced as a judgment. And we said, no, we could not enforce that agreement because it was contrary to public policy. Public policy being that laws must be obeyed by everybody, and that the prime minister could not properly allow an investor to abide by a framework that was at variance with the published laws of the country. So I note with tremendous interest that there are some states that have recognized the problem of prime ministerial government and have, certainly in Guyana, enacted legislation, and as it is the intention here, to enact legislation that would take measures to address the situation. The issue of the constitutional validity of the Guyana legislation has actually been placed before the courts of that country. And our court, the CCJ, is the final court of Guyana. So I am reluctant to say anything more about that issue, given that it is a matter that can or will soon reach the CCJ. But certainly it is open to one to say that measures that might address the democratization of decision-making, measures that will enhance the rule of law, are certainly measures which I could hardly see anybody wishing to quarrel with. Other more obvious measures have been taken by CARICOM governments and parliaments to advance the rule of law. And these have included, to name just a few, the establishment of freedom of information legislation. It was the great American Supreme Court Justice Louis Brandeis who first coined the phrase that sunlight is the best of disinfectants. In other words, if you have transparent procedures, if you have access being given to the public to discover for themselves the rationale for certain kinds of decision making, then just that by itself will conduce to good governance. I know that this idea of accountability, there are some people who feel that judges are not accountable because they don't have to go to get elected like parliamentarians do. It's difficult to impeach a judge. There's a procedure for it. But I take the view that of all the public officials that are set out in the Constitution, whether the Speaker, the Prime Minister, the Leader of the Opposition, all the public officials, judges are the most accountable. Because in the first instance, they carry out their work in the full glare of the public. People could come in and see them carry out their work. They have to give reasons for the decision. Invariably, those reasons should be given in writing so that the public can scrutinize those reasons. If you're dissatisfied with those reasons, then you could appeal to a higher set of judges. Other public officials don't go through those kind of processes. Some of the decision making they make, you don't know how they came by those decisions. They're not obliged to give you any reasons for those decisions sometimes. So that freedom of information legislation is very important in order to bring these other public officials a little bit closer to the situation that we as judges have to endure, where we can't just give a decision and not give you the reasons for it, or give a decision in secret and not allow you to be able to have a lawyer to argue as to why the decision should be this way or that way. But that's just an aside. The basic point is that I certainly think that freedom of information legislation would go a long way to addressing the issue of enhancing the rule of law. And I could confidently say that because there isn't any case before me now about the freedom of information legislation. So too is naturally the enactment of anti-corruption or integrity legislation. In Trinidad and Tobago, where I have been living for the last 12 years, there's an integrity commission. Unfortunately, there have been complaints that the commission is not sufficiently well-resourced and that there are obstacles in the way of its effective functioning. And I would like to say that if we're going to establish anti-corruption or integrity commissions, then they need to be well-resourced so that they can effectively do the job which they are designed to do. Or otherwise, they become what we in the Caribbean call a pappy show. And if they are a pappy show, then people will recognize that right away. And far from enhancing the rule of law, it will lead to disillusionment and to damaging the rule of law. Of course, the duty to uphold and advance the rule of law doesn't end with the courts and the government and the parliament. Civil society also can play a huge role because they're often the mouthpiece of minorities and the more vulnerable groups in our society. And one indicator of the extent to which the rule of law is observed is actually the attitude of the executive to civil society bodies that are either from time to time critical of the government or passionate in the promotion of their interests. I believe the most significant area of challenge to the rule of law in many states of our region is the alarming increase in violent crime. A major cause of this, of course, lies in our geography. We are small, poor Caribbean island states, and we just happen to be wedged right between the major producers and consumers of illegal drugs. With our long stretches of unprotected coastlines, Caribbean states provide a much utilized transit point in the illegal drug trade. And that has been a significant factor in the promotion of gangs and in spiraling homicide rates that we are experiencing in many of our Caribbean countries. Control of crime is a multifaceted enterprise, but an important component is criminal justice reform that is designed to address the low conviction rates, unbearably long periods of pretrial detention. Actually, I think that pretrial detention is a scandal in some countries. I know in one country, if you are charged with murder, sometimes it takes 3, 4, 5, as much as 10 years before your trial is heard. And that's absolutely scandalous because in the meantime, the person is innocent until they're proven guilty. And indeed, I know of instances where persons who have spent 10 years on remand have been acquitted on a no-case submission. And I just find that just very sad and shocking. But we need effective criminal justice reform, and this requires a holistic approach that integrates the coordinated efforts of all the key stakeholders, whether government, parliament, police, prison, prosecution, bar association. All of these various elements that comprise the criminal justice system need to be on the same page, working together in order for there to be effective criminal justice reform. Or otherwise, what can happen is that one unit takes a decision in good faith that it thinks is important in order to tweak or to get rid of some creak in that particular sphere. But invariably, that decision has a knock-on effect on the other units, and they would be faced with some unexpected issue arising from the decision taken by the other unit. In closing, I would simply say that despite all of these challenges, I am very optimistic that as a people, we are capable of meeting them. But doing so will require a huge effort, it requires steadfastness, require patience, and respect for each other's views. But I really do believe that people's consciousness rises over time. Our populations will continually hold governments and public officials to higher and higher standards of accountability, which in turn will produce better government. And I'm certain that if we compared ourselves to where we were 30 or 50 years ago, we will see the progress that has been made. And all that we need to do now is to press on with urgency and confidence and faith and an appreciation that we can, in fact, take the necessary measures which must be taken in order to enhance the rule of law. I thank you very much.